Hello and welcome to our training today on capacity-informed consent in the care process. Today we're going to look at what capacity and informed consent is in general, and in particular how it looks like in the care process. So let's take a look at that agenda. So we have those two major sections. The first is an introduction to capacity and informed consent. And then, like I mentioned, we'll specifically look at that in the care process. And just a note that all of our talking points are included in the training materials. So the PDF is located on our website, and you can see all those talking points as well as the slides, so you can follow along during the training. So our learning objectives today, our goal is that by the end of the session, you will have an increased ability to describe the concepts of capacity and informed consent in the context of the CARE Act, define the factors that ensure informed consent, and then list strategies to support the respondent to give informed consent. So let's take a look at who will be leading us through this conversation today. We have Dari Pogach, who is a senior consultant with Health Management Associates. And Dari has more than 15 years of experience in working with clients and communities and nonprofit organizations. She's a subject matter expert in supported decision-making as a legal theory, and then also in how that applies. We also are joined today by Dr. Mark Avery with Health Management Associates, who's a board-certified psychiatrist and a leader in the subject of person-centered integrated psychiatric care. Our third presenter, we're pleased to be joined by Richard Cousins, who provides consultancy to the Criminal Justice Services Office of the Judicial Council of California, and he's previously served in Placer County Superior Court and served by assignment as the Assigned Justice Program for nearly 20 years. So we're pleased to have these three different perspectives help us understand capacity and informed consent in care, and I'll turn the time over to Dari. Dari?
Thanks, Patricia. Thank you so much to all of you for joining us to talk about this very important issue. I just want to say I'm so pleased to be here with my co-presenters today. I think we bring three really different and important perspectives. I personally have a background as an attorney representing clients with disabilities for much of my career, and then going to work on policy issues related to decision-making and capacity for older adults and people with disabilities. And then my colleagues, who I'm sure can tell you more about their experience when they get the mic, but we've got Dr. Avery, who has this amazing clinical background, and of course, Judge Cousins with decades of experience on the bench. So I'm really looking forward to our conversation today and to sharing these different perspectives with you. This also leads into what I want to say about capacity and consent generally. It's a really broad topic. It applies to really all legal and clinical matters related to mental health treatment and supports and services. And you can go to the next slide, please. Thank you. So because this topic is so broad, we want to really make sure to set the stage for the rest of the hour. We're really going to try to focus today on capacity and informed consent as they relate to the CARE Act. And so you may be familiar with these concepts in the context of LPS conservatorship or other forms of legal decision-making. And we're going to be looking at those intersections, particularly with LPS, because it's so relevant to care. But ultimately, this conversation is really steeped in how these topics relate to care specifically, talking about the decisional capacity to give informed consent to psychotropic medications, and then the consent to participate in the CARE Act process itself. I also want to really enforce the idea that these are fluid, interdependent concepts, and they can be messy and they can be hard to define. And there are challenges in providing clear-cut definitions that resonate in real-world situations. And I anticipate there will be challenges in how these concepts play out as the CARE Act rolls out and we see more and more case studies. But ultimately, and I know my co-presenters agree with me on this fundamental principle that every individual is presumed to have capacity to give informed consent, regardless of diagnosis or other extenuating circumstances. And we're all starting from that presumption. So we can go to the next slide. Thanks. So we're going to really focus on a balance today. We're going to be looking at autonomy and self-determination and stability, safety, and well-being. And we talked a lot about this graphic, and we ended up with a scale. And I invite you, as we go through this presentation, this is not a autonomy and self-determination versus stability, safety, and well-being. These goals don't have to be exclusive of each other. And in fact, the way the CARE Act is laid out, it's really about balancing these two crucial needs to a person's mental health treatment along the CARE Act process. So ensuring someone has stability is someone's life, someone is stable, safe, and enjoys well-being is crucial to preserving their autonomy and self-determination. And I would argue the same vice versa, and we're going to talk more about that today. The CARE Act lays out a framework for assessing capacity to provide informed consent, specifically related to medication, and it also lays out a framework for supporting the goals of supporting a person's stability and well-being. The bottom line is consistent, compassionate services can support both of these goals, and we're going to be talking about that throughout the presentation today. So we can go to the next slide. So what is capacity? The CARE Act doesn't provide this. The CARE Act statute does not provide a definition of capacity. So we'll be using the California Probate Code's definition as the basic definition. And what the Probate Code lays out is that capacity is about a person's ability to understand the nature and consequences of a decision, to make and communicate a decision, and to understand its significant benefits, risks, and alternatives. We're going to get into, during this presentation, who determines capacity, and we'll talk about the role of healthcare providers in assessing capacity, and then how a judge goes about making a determination of capacity in a legal setting. And I'll defer to Judge Cousins when we get to that slide for a discussion of that role. Right now, I'd like to hand the mic over to Dr. Avery to talk about how capacity fluctuates or can change over time.
Thank you, Dari. And I'd like to echo your sentiment about happiness to be here today to talk about this really important subject and to be able to do this in the context of some really amazing colleagues here. So thank you very much. So the next concept of capacity, Dari mentioned that that the definition of capacity is fluid in one sense, and the capacity is also fluid in another sense, in that capacity changes over time, sometimes really quite dramatically so. So factors such as illness, medications, other temporary environmental factors can all play a role in that. So, for example, a person may present with delirium and not have capacity one day, and the next day the delirium clears and that capacity then restores. So it's important to not think about capacity as an ongoing, unchangeable feature. It's really quite the opposite.
Thanks, Dr. Avery. And I just want to make one final point to distinguish between capacity and competency. These terms are often confused with each other by everyone, not just lay people, but professionals, including the three of us. And we had a discussion about this while preparing for this presentation. So please keep in mind that capacity is about, the concept we'll really be digging into today is capacity. Competency is a term that comes up that is related to criminal court proceedings. And so I just want to make sure we make that distinction. So we can go to the next slide. So now we're going to talk about capacity in clinical settings and court proceedings. And Dr. Avery, would you like to start with the clinical settings?
Yes, thanks again, Dari. So again, the capacity is applied in these two different settings, and in clinical settings, capacity is something that applies whenever a clinical recommendation is given. So that means every clinical recommendation that's ever given, capacity applies, whether it's to take an antibiotic medication for a sore throat, or to agree to have a surgery, or to take a psychiatric medication. In a lot of these instances, the presence of capacity is just presumed. So those of us that have gone to a doctor's office and received an antibiotic medication for a sore throat, in that case, your prescriber or doctor likely presumed that capacity was present. Having capacity is integral to obtaining informed consent for that treatment, and the concept is ongoing, as mentioned before. Sometimes when things get very confusing, us clinical folks have to consult with judicial folks to help us with a judicial determination or hearing when the presence of capacity is uncertain. And with that, I'll hand the mic to Judge Cousins to take us. So how does that apply in those court proceedings?
Well, thank you, Dr. Avery. The courts do get involved in a variety of different contexts with dealing with capacity. Typically, a judge reviews a clinical evaluation in determining capacity prior to making that judicial decision. The concept of capacity, of course, is a very important and fundamental factor in determining whether ultimately I, as a judge, will have to issue some form of an order. So, because as we have indicated, we presume capacity, but in situations where that becomes a question, we need to analyze it from a legal standpoint as well. It usually comes up in a situation where the behavioral health staff wants the respondent, the patient, to do something, usually takes the medication. But two things become very evident very quickly. The first thing is the patient's not going to do it. They don't want to take the medication, and so they refuse. And then the second thing that becomes evident is that the patient really doesn't understand the consequences of the decision, is not processing the information in a way that creates an informed decision where they really understand the consequences of their decision. And that's the cusp, the gist of capacity, is making an informed decision about this. So the law is very clear. While the clinical evaluator is very important in determining initially the problems with capacity, it ultimately takes a person like me wearing a black dress, a judge, to assess these factors and make a decision whether capacity actually exists. This evaluation will be made following clinical evaluations, perhaps a hearing where evidence is taken, but we try to gather as much information about the person to determine whether the capacity actually exists. And again, capacity is a very precise term. It means the ability to understand the nature and consequences of the treatment, to make and communicate a decision about that. And to weigh the consequences, weigh the risks, weigh the benefits, and weigh the alternatives. We can only change the person's ability to make that decision for themselves if we find by what's called clear and convincing evidence that the person lacks capacity. Under the law, clear and convincing evidence is an extremely high standard. It's the second highest standard we have under the law. It's second only to proof beyond a reasonable doubt in a criminal case. So the consequence of that standard is that the judge really has to be very confident in that decision, that they are making the right decision after carefully considering all the variables that may be involved. So we are very cautious about that. If we determine that a person is not competent, we are taking away a valuable right which is the self-determination of treatment. And so we do that only under this very strict and narrow circumstances. Having the court involved with this process very early on is very helpful to everybody because it will assure a level of due process to everybody, that is fairness. Because the court is not representing anybody in the proceeding, but trying to facilitate that process. And it also assures that everybody will have an opportunity to be heard, to express their concerns. So the court's ability to step into the middle of this is very crucial in a fair and appropriate determination of capacity. Dari?
Thank you, Judge Cousins. That was so helpful. We can move on to the next slide, and I'm actually going to ask Dr. Avery to talk about informed consent.
Great, thanks, Dari. So putting our clinical hat back on, we've gone back and forth here from clinical to court proceedings, back to clinical here, is perhaps the most common application of the concept of capacity is when we obtain informed consent, or when we give informed consent for a procedure, or in a broader sense, when we consent to treatment in general. So then what does that mean? What is consent and what is informed consent? So the broader term, consent, is merely the act of agreeing or giving a permission for something to happen. You know, maybe yesterday I agreed to do dishes after we finished dinner, so I consented to do dishes, right? Consent just means that a person is choosing to participate, and that broader term consent does not necessarily require an assessment of capacity. It just means you're saying yes. So why do we specify this? Is because with regards to the concept of consent in relation to CARE Act, a CARE Act respondent can consent to participation in the CARE Act. And we're referring to the respondent exercising their choice to voluntarily participate and engage in the care process, regardless of their capacity at that point. And this is because consent is important to an individual's self-determination. We want to maximize that as much as possible, as well as their comfort with those procedures or medications. We want to maximize that as well. So what about the more specific term, moving from consent to informed consent, something we do very often in healthcare, and especially in mental health situations, where whenever we prescribe a medication, for instance, we almost always get informed consent. What does that more specific informed consent term mean? And it refers to a process where that consent is obtained in the context of that person being fully educated about their options, understands the implications of a treatment before agreeing to it. It's actually defined in California law, and it refers to the ethical and legal requirements for us healthcare providers to obtain someone's agreement for a treatment only after providing them with adequate information about the nature, benefits, risks, and alternatives of the proposed treatment. And we actually have to check that the person understands that information. So we go through all of this to ensure that that person can make knowledgeable decisions about their healthcare, and they're not making decisions in error because they didn't have the right elements to make that decision. And so what are those elements? They're listed here in the slide, and there's more details in the notes if you'd like to read them later. But first, we have to disclose all those elements that I had mentioned, the nature, benefits, risks, and alternatives. We have to check to ensure that the person understood that information. If they consent to the treatment, we have to verify that that consent was voluntary, that they weren't coerced in any way, for instance. Here's that word capacity, that they have the capacity to go through all of those steps. And in many instances, especially when it comes to psychiatric medications and other things like surgeries and whatnot, we have to very carefully document all of those elements that I just mentioned. We could go to the next slide, please. So how does this apply, the concept of capacity and informed consent? How does it apply specifically to the schizophrenia spectrum and other spectrum disorders? These concepts are important topics for all aspects of mental and physical health, but especially in the concepts in the context of mental health, and specifically even with schizophrenia. And why is that? And that's because the symptoms of schizophrenia and the related conditions can particularly affect a person's ability around capacity and informed consent. So, for instance, a person with those conditions may experience anosognosia, which is a situation where you may have pretty dramatic symptoms, but you may not have insight or awareness that you have those difficulties. That, of course, can then impact your ability to understand the necessary treatment options and the implications of their choices. Other aspects of schizophrenia spectrum conditions can play a role as well. So there are these symptoms referred to as the negative symptoms of schizophrenia, such as demoralization, lack of motivation, decreased feelings and emotion. These might lead to a sense of passivity or an apparent lack of interest in making decisions. Persons with schizophrenia spectrum disorders can also have disorganized thinking and even cognitive impairments, which of course could interfere with their ability around capacity and informed consent, as well as could the more dramatic symptoms of schizophrenia, such as delusions, hallucinations, and paranoia. Familiarity with these symptoms, understanding what they all are, can be especially helpful when assessing an individual's decisional capacity, and should certainly inform the clinician's approach with the individual during that assessment. Okay, with that, I'd like to hand the mic back to Judge Cousins to talk about the concept of grave disability.
As sort of an introduction to these concepts, it's important to understand that the CARE Act, because of the players involved, is going to involve the potential collision of various concepts that have very similar meanings. We have the grave disability concept that we have touched on, decisional capacity, which we are working on, and there's also competency. Competency, as Dari indicated earlier, is a criminal concept which addresses the ability of a defendant to understand the nature of the criminal proceedings and to assist in their own defense. That obviously is not a part of the CARE Act, since that's part of the criminal process. But lawyers and judges and even professionals who work in this area frequently conflate or mix up these terms, and it's important at the outset to understand that each is separate. They're going to involve a number of similar considerations about the ability of the person to process information. So there will be similarities, and the existence of one of these disabilities will inform and perhaps affect the others. But it does not mean that because one exists, they all exist. And it's certainly possible that a person can be gravely disabled, for example, but still have the capacity to give informed consent to medication. So while they're useful, we have to keep them separate. Each has their own definition. Each has their own legal consequence once it's found. And the understanding of that will help you, I think, wend your way through these complex and seemingly interchangeable concepts, which they clearly are not. So, Dari, I think you'd like to talk more fully about grave disability in terms of how it operates in the CARE Act.
Thanks, Judge Cousins. I think you pretty much said it all, defining these concepts. Just, I want to say briefly, in the context of care, so grave disability does come up in the CARE Act statute, but it's only mentioned with reference to the eligibility criteria. The idea is that one of the criteria for eligibility for care is that these supports and services are needed to prevent the person's deterioration that may result in them becoming gravely disabled. So gravely disabled is, care is can be a preventive measure to a person meeting criteria for gravely disabled and then perhaps becoming a candidate for LPS. And the statute also goes into care as an alternative or a preventive measure to the more severe limitation of a person's self-determination and autonomy through the LPS proceedings. And again, this is just highlighting that the intention of care is to divert someone from or to support them so that they don't further deteriorate or decompensate in a way that may impact their decision making and again lead to more restrictive measures like LPS. Some of you may also have heard of or be aware of Senate Bill 43, which expands the definition of grave disability to include individuals with severe substance use disorders, including co-occurring mental health and SUD. And this new law will go into effect in California in January of 2026, and we have more information about SB 43 in the notes. And with that, I'm going to turn it back over to Dr. Avery to talk about implicit bias.
Thanks again, Dari. Before we wrap up this section on talking about the definition and concepts around capacity and informed consent, I want to make a couple clinical points here. First of all, although we've given you a fairly clear definition of capacity and informed consent, that doesn't mean that the assessment and determination of capacity and informed consent is always clear and easy to do. Actually, it's quite the opposite, that it's one of the more complicated things that healthcare providers are oftentimes engaged to help sort out, is whether somebody has the capacity to give informed consent. One of the reasons for that is because of the concept of bias. So we wanted to do a bit of a reality check here to back up a little bit to think about how our own sense of bias, including implicit bias, can affect our assessment for capacity. So we do have a full training on bias in our library for more information on this concept. But let's talk a little bit about it here, just a couple slides. What is bias in the first place? So bias is a positive or negative tendency resulting in attitudes, decisions, behaviors, or actions that are prejudged in favor or against something. That's the concept of bias. Implicit bias is one form of bias that occurs unconsciously. So for example, let's say I move to a new area and I only seek out those who look like me to learn more about the area. I might not be consciously aware that I'm doing this, but I might just not ask for everybody's input when I do that. That would, of course, lead to sort of a biased perspective of what that new area is for me. And so that whole process happened unconsciously. And I was unaware of it. So once again, implicit biases can impact our assessment of whether a care participant can make their own decisions. They can influence our behaviors toward that respondent. Then that could, have things down the road about how then the respondent behaves back to me. It can limit our own thinking. It can close our own minds about the individual or respondent's unique situation, context, and path to recovery. And it can affect our relationship with the respondent or patient. So moving to our next slide, what sorts of things can we do to mitigate the impact of bias when we're assessing for capacity? And again, more notes in the slide deck, and yet again, additional information in the other presentations specifically on this subject. But you can help to mitigate your bias in your assessment of capacity by first just considering how an individual might have capacity. So capacity is fluid, as Dari mentioned very early on in the talk. They may have capacity in some ways and not capacity on others. It also helps to focus on the person's ability to make decisions rather than focusing on symptoms. So for instance, somebody might have hallucinations or delusions, but still have capacity fully in place, fully able to make informed consent decisions. In fact, that's fairly common. Even in the concept of capacity being altered, consider the least restrictive alternative for addressing that situation. And even in the concept where capacity is uncertain, you still could obtain the person's preferences or values in regard to their health care. So, so if you apply these and the other standards shown here on the slide, you can really help to both recognize and ward off the impact of bias as you're going through the capacity and informed consent assessment for your patients and respondents. And with that, I'm handing the mic back to Dari.
Thanks, Dr. Avery. So we've talked a lot about capacity and informed consent, but I'm still trying to think about how we can articulate the relationship between capacity and informed consent, and then really drilling down into why is this so relevant to care? So Dr. Avery, I'd invite you to respond to this, Judge Cousins, and we can have a dialogue answering this question.
I might say that there's a sort of a foundational relationship between these two concepts. And I think if you look at it that way, it may be easier to understand. Because everybody is presumed to have capacity, we have to at times assess whether they can give informed consent. That capacity is critical to the ability to give informed consent. If it's not there, it's not going to be obtained, and we have to get the help of the court to resolve that. So we look to whether the person has that ability, that capacity, if you will, to make the informed consent. And where we find that is lacking, then that can empower the court to enter an order that will facilitate treatment, even though the respondent is objecting to it.
I'm going to jump right in. As a psychiatrist, I can't help but to mention that in the behavioral health world, the relationship is the biggest part of what is therapeutic about us. So when we talk about, oh, my therapist was really excellent, what we really mean is my relationship with my therapist, how I interacted with my therapist was helpful to me. So the relationship is really what it's all about. And the concept of capacity and informed consent is really integral to that relationship. How decisions are made, how recommendations are made, is that done in partnership? Walking through those steps, keeping those steps in the back of your mind, really with all your recommendations and all your services, helps us to be much more effective. So this is no different in the CARE Act proceedings, where these concepts are really at the forefront. And so the better we understand the concept of capacity informed consent, really, I think the more effective the whole CARE Act process will be for those respondents that go through that process.
Well, thanks to both of you. I do also want to take a minute to look at this third bullet, talking about internal and external variables and how they can influence both a person's capacity and the clinician's evaluation. And from my own experience as an advocate representing individuals with psychiatric disabilities in court proceedings like guardianship and mental health commitment proceedings, those external variables are really significant. And I just want to point out, in addition to implicit bias, stigma, there's also poverty. If someone is hungry or stressed because they don't have stable housing, or a whole variety of other circumstances that I'm sure both of you could discuss and our audience is familiar with, those factors can also really influence how a person responds to an assessment of capacity, to how they're perceived, but also just to their thinking and how they relate to the whole process. And so as we move into our next section, where we'll be talking about the CARE Act process itself, I just want to be sensitive to that too, as we're talking specifically about these individuals who will be going through care, what the external factors are that may influence their capacity to give informed consent at any moment, as Dr. Avery has pointed out, because it's a fluid state and can change over time. So with that, we'll go to the next slide. So now we're going to talk about capacity and informed consent in the care process. Californians suffering from untreated schizophrenia, spectrum, and other psychotic disorders face significant health and safety risks. And the goal of care is to provide these individuals with the services they need to thrive in community settings. So in this next section, we're going to look at the tools and the strategies that are available through the CARE Act process to balance the need for treatment with the individual's right to self-determination. And I just want to make one more point, which is every person is unique. This gets back to my original point about how messy and complicated these concepts can be. And so every individual's trajectory through the care process is going to be different. And that balance that all of the individuals involved in the process, as we'll talk about, are seeking or striving to maintain between the person's right to maintain their autonomy and their right to self-determination, and also the person's right and need to be stable and healthy and enjoy a level of well-being. That balance will be different for everyone too. And so I just wanted to set the stage because as we go to the next slide, please. We're going to talk about a specific person. Now, this is Mary. Of course, Mary is hypothetical, but she is a unique hypothetical. And so as we go through her journey, I just want to point out that, again, this is in some way specific to Mary. So meet Mary. Mary is a unique individual who is about to embark on the CARE Act process. She's 47. She's single. She has diagnoses of schizoaffective disorder and opioid use disorder. She's declined antipsychotic medication for the last 6 months. She's currently unhoused. She has a sister. Her sister tried to engage with county behavioral health to get services for Mary, but BH tried to meet Mary on the street and offer services, and they were not successful. And as Mary starts this CARE Act process, she has a volunteer supporter. It's a peer supporter that she met at a shelter. Okay, next slide, please. So now we're going to talk more specifically about the care process. Let's look first at the relevant points in the process where a person's capacity to give informed consent and make decisions is taken into consideration. You see here we have an overview of the full care process. So consent, of course, broadly comes into play throughout the process. Ideally, a person can consent to treatment, housing, support. But what we're talking about, of course, in this presentation is informed consent, which would includes an assessment of capacity of that individual to provide informed consent. That's going to come into play in 3 parts of this process: the case management hearing, the clinical evaluation and hearing, and the care plan review hearing. So I just want to very briefly point out as you go through this slide, the full care process is after the initial petition is filed and the person, there's either a prima facie determination that goes straight to an initial appearance, or perhaps a court review of the report may be ordered. And then we're going to end up at a hearing on the merits to determine whether the person meets the criteria for the CARE Act process. For the CARE Act, at this point, if the person meets the criteria, the court is going to hold a case management hearing. And let's go to the next slide. And so this is where there are 3 points that we're going to talk about more specifically where capacity and informed consent come into play. So first, at the case management hearing, the court will make a determination if the parties are able to enter or likely to enter a care agreement. It's important to note that the Welfare and Institutions Code doesn't specifically mention capacity to provide informed consent at this hearing, but it's possible that during the case management hearing, it will be evident that the respondent's mental state prevents them from reaching a voluntary agreement, or the court will determine that the respondent lacks capacity to agree to any plan or treatment. So if the care agreement is not likely to be reached for whatever reason, the court will order the county behavioral health agency to conduct a clinical evaluation. And that clinical evaluation, which my colleague Dr. Avery will speak to in more detail in the next slide, includes a few different statutory points. But for the purposes of this slide, the clinical evaluation will include a diagnosis and assessment of capacity to give informed consent regarding psychotropic medications and other recommendations. And then at the hearing, the court will review the evaluation and then determine if the person meets the care criteria. The court can then order the parties to develop a care plan. And then finally, we have the care plan review hearing. So in the care plan, the court can order medication if it finds, by clear and convincing evidence, that the person lacks capacity to give informed consent to the administration of medically necessary stabilization medication. It's important to note here that this order does not authorize forced medication, but it can still be an important component of the treatment plan, and it can justify non-forcible actions by behavioral health agencies to encourage the respondent to take the ordered medication. Also, this legal measure helps overcome barriers to prescribing critical treatment for the care population. And I'm going to turn now to Mark.
Thanks again, Dari. And so what is that clinical evaluation that Dari just mentioned? Us behavioral health providers, we are very used to performing comprehensive psychosocial evaluations. But you should be aware that the CARE Act actually has a fairly specific definition of what they mean by a clinical evaluation. So at a minimum, as you can see here on the slide, that clinical evaluation must contain these 4 components. 3 of them we're very used to doing, and one of them might be is what we're talking about today. So it must contain a clinical diagnosis, which most of us behavioral health providers are used to doing. I'm going to jump to the 3rd one. Additional information to help the court make future informed decisions regarding care and services for respondent. And then our analysis of those recommended services and interventions that support the respondent. But note that there's this element which is in the 2nd bullet of this slide. We also must comment on our clinical assessment of the respondent's legal capacity to give informed consent regarding psychotropic medications. So because that must be part of the clinical evaluation, I do want to say, it's very likely that you will want to engage the person at your office or agency that routinely does informed consent. In other words, your prescriber or your psychiatrist or nurse practitioner. So you may need to engage that person in doing the clinical evaluation. So if we think back to Mary, the vignette that we presented earlier, as she goes through that clinical evaluation, some of the elements, the diagnosis, the assessment of recommendations and additional information, that could possibly be done by the person's primary clinician, whoever that is there at the behavioral health office. But they may want to turn to the psychiatrist. In Mary's case, she does have a psychiatrist to comment on Mary's legal capacity to give informed consent regarding psychotropic medication. So let's move to the next slide. So what does that mean? How can we document our assessment of the person's legal capacity to give informed consent regarding medication? Well, we recommend you walk through these 4 elements. First, assessing and documenting whether the person's understanding of their mental condition, the recommended treatments and services, as well as alternatives if those are present. That you document that the person understood and appreciated what all the educational material was, so they're able to understand the benefits, risks, and alternatives, and that they have an ability to reason through and can understand and knowingly evaluate that information. And then the final thing is that they're able to express a choice regarding their decision and explain why they are making it. So those 4 steps. So how do we actually do that? Well, there's no really right way to do it. If we go to the next step, as Daria mentioned earlier in the talk, everybody's experience in the CARE Act will be unique. And so how we assess capacity for every person would probably be unique as well. So there's lots of ways to do that. So we give you examples here of questions that you might ask in order to assess and document the person's understanding, how they appreciate the consequences, how they would reason through, and their ability to express a choice. We could suggest more questions here. There's a lot of ways to assess for it, and these are just some great examples for you about how to do that. And with that, let's move to the next slide, please. Because with this, I think perhaps for me, this is what a lot of what we've been talking to really boils down to, because this is one of the key elements here that we're going to describe in this slide about how the CARE Act is meant to improve the outcomes of the people who are enrolled in the program. And this is how. So under usual circumstances, a clinician or prescriber usually is legally and ethically bound to obtain informed consent before prescribing psychotropic medication. So back in the paper days, we had, informed consent documents that we had to fill out for every single medication that we prescribed. And in electronic medical records, they now have those as well. However, in the case of prescribing medication, it can be a barrier for the CARE Act population to have an access to a critical component of their treatment if the person doesn't have that consent, and therefore you can't document informed consent. If the prescriber finds that an individual lacks the capacity to provide informed consent, but the person still needs that medication, the subsequent court-ordered medication can help to overcome that barrier, because once it's court-ordered, the prescriber can now, in good conscience, prescribe that psychotropic medication. Note that a court order does not order the individual to actually take the medication. It just allows that prescriber to write for that medication, so that medication then becomes available. So even though the medication may not be forcibly administered, the behavioral health provider is now legally able to prescribe medication with that court order, even if they feel that they're not able to give informed consent. So this is the point that I think is really important about how we think the CARE Act may benefit folks. And so this reduces that obstacle that a prescriber and a respondent might have, where in the office, if the respondent is refusing medication and there's no next of kin or power of attorney immediately available, in ordinary circumstances, the prescriber would be stuck at that point. And now with this court order, the prescriber is at least able to order the medication and get that medication ready. Judge Cousins, did I say that all right, or is there anything else you would like to add about that?
Everything you said is absolutely appropriate, Dr. Avery, but I would add an additional thought. Given human nature, what it is, everybody is on a spectrum. There are going to the people that appear in front of the court, there is going to be a group of people who are absolutely clearly competent, have the capacity, and it's no issue. Then there's going to be a group of people who are slam dunk incompetent, who totally lack the capacity to give informed consent. But there's this middle group, and it's going to be a difficult group to work with because they don't quite fit, yet we have to make decisions. And so I can't stress enough the power of the black dress, that person in the position of authority, hopefully in a friendly and not authoritative way necessarily, but a friendly, inviting way, engaging the individuals to try to finesse this issue so that you don't have to bring everything to the court as a matter of warfare, but to try to use the courtroom as a forum for facilitation, discussion, compromise, understanding, so that people can be finessed into making voluntary decisions, and be willing to accept them and appreciate them, rather than to have things done over their objection. That is so much more difficult. And I think, Dr. you would probably agree to me that voluntary participation is so much better, if it works, than the other way around, where we're imposing things over people's agreement. That is our goal. The goal is to make the individual a standalone human being and an ability to exist in our community. And this is a big part of that process.
Absolutely. I think that's a really great point you make, Judge Cousins, and I really appreciate that. Okay, thanks. And so with that, I'd like to hand the mic to Dari to take us through some CARE Act roles. Next slide, please.
Great, thank you. We're going to come back to Mary and talk about her experience in the CARE Act process and the role, each of these roles, and how each of these individual roles should be, has a duty really to support Mary, to make informed consent whenever possible, to support her to enjoy decisional capacity to the greatest extent possible. And I'll speak to the first three, and then of course I will hand over to our subject matter expert, Judge Cousins, to talk about the courts. So let's talk about county behavioral health staff. In our introduction to Mary, I mentioned that County BH did try to engage Mary on the streets before she became involved with the CARE Act process, and they were unsuccessful. So now that there is a care plan in place, County BH have had an opportunity to get to know Mary, to become more involved with her, and also to learn a little more about what professional strategies they can employ to share information and offer services in the most accessible way possible for Mary. And then we have the volunteer supporter. That's, you may remember, the peer supporter that Mary met at a shelter. So I do want to say we have a great training on the role of the volunteer supporter in our library if you're interested in learning more about the volunteer supporter and how they can use supported decision-making to best support the person. In this case, what are some things that this peer supporter might be able to do to be a part of Mary's journey and processing information and ensuring her preferences and wishes are reflected in the care plan and throughout the process in hearings if the supporter is interested in Mary, wants the supporter to be there in court with her as well. So the supporter's there, again, to work with Mary, to support her autonomy, to talk to her about what she wants to maintain decision-making authority as much as possible. And also, if possible and appropriate and in alignment with Mary's desires, to help Mary communicate what her wishes and preferences are. Again, I think this is sort of a mix between those internal and external factors that might affect a person's capacity to give informed consent. And a lot of this is about communication. Does Mary feel comfortable and supported to communicate what it is that she wants to, which is another form of consent, right? Of taking in the options and then deciding what it is that she wants to do. And then finally, we have counsel. So in court, of course, counsel's there to support Mary and to ensure that her voice is heard during court proceedings. And that, again, this comes to communication. So to ensure if Mary does have capacity to give informed consent, that she has the opportunity in court to communicate her expressed wishes and desires and consent to treatment. But also outside of court too. Counsel is available to Mary to have those conversations and to provide support. And I'm going to talk more in the next couple of slides about some tools and strategies and resources we have more specifically for supporting someone to make their own decisions and communicate what it is that they want. But before I do that, Judge Cousins, can you please speak to the role of the court?
Sure. I think the role of the court is uniquely defined because of the neutrality. The judge is the only person in the courtroom charged by law with being neutral. The judge doesn't represent behavioral health, doesn't represent the respondent, but is responsible for looking after the rights of everybody in the courtroom and the entire process. And that is a very powerful position because most people do respect the authority of the court. In Mary's situation, for example, the judge, in a very calm and simple way, explaining the court process, explaining what the petition is about, explaining where things are going to go, might go a long way in encouraging voluntary participation without having to precipitate a fight over competency and capacity and informed consent. I think the judge can, as we've seen, go a long way to broker things for Mary, bring in people who might be helpful. It's a rare person who doesn't respond to a judge picking up the phone and saying, "Hey, come on down and chat. We need your help." And they come and they can give their input. It can be very powerful in giving services to an individual who needs a particular problem answered. And it's this collective resolution of everybody working together that hopefully will give Mary what she needs to survive.
Thanks, Judge Cousins. So we can move to the next slide. And I do want to thank you again, Judge Cousins, for pointing out the court's unique role as the singular neutral party. I think that's a really great point. And the ordering of our slides was deliberate to let you to save that part for last. But going back to meeting individuals where they are, this is my passion with my background as an advocate. And these tools, they seem simple, but I think for all of us who've been part of, who've either participated in mental health court proceedings or provided mental health services, sometimes during a crisis or dealing, working with someone who may be experiencing, their psychiatric disabilities are impeding their ability to give informed consent or impeding their capacity to give informed consent. Sometimes it can be hard to remember some of these really what seem like kind of simple strategies. So we're just going to go over them here. So simplifying information, this is so important. And Judge Cousins, I'm sure you've done this many times from the bench. I've seen the power of a judge speaking to a person in a court proceeding and really just breaking down information in a way all of us can understand. Because any of us who are not familiar with court proceedings, these processes can seem really complicated, confusing. So really simplifying information. Don't be afraid to repeat an explanation. Sometimes we need to hear information more than once to really process it. Visual aids can be really useful, and sometimes they can even replace verbal communication. For some people, they're much more effective. So my first three were relatively concrete. I'd say those are kind of the low-hanging fruit. Creating a supportive environment, involving support systems, and using supported decision-making. These are obviously much harder strategies to employ, but so powerful when we're able to employ them. Trying to keep the environment calm and supportive. And I encourage you to seek our incorporating trauma-informed care into the care process for behavioral health agencies training in our library. It's got just really great strategies on creating that supportive environment. If the person has outside supports, like a volunteer, like Mary's peer supporter, Mary's sister, other natural supports, family members, peers, they can be really helpful. It's not just the volunteer supporter. I want to acknowledge that not everyone is going to have those natural supports, but if they do, it's a really wonderful tool to use during the care process. And then supported decision-making strategies. And let's go to the next slide. We have a training in our library that really gets into supported decision-making. Briefly, supported decision-making is a framework. It's about the supports and services that help an adult with a disability make his or her own decisions by using family, friends, professionals, and other people they trust to help understand issues and choices and ask questions, receive explanations in language they understand, and communicate their own decisions to others. So in some ways, that supported decision making network is really about incorporating all the prior strategies I described in the previous slide of meeting the person where they are. And again, I encourage you to check out our more extensive training in our care resources library. Next slide. So another really what can be an effective tool if used if available is the Psychiatric Advance Directive. I'm really proud to say we also have a training on this in our CARE Act Resources Library, which gives a lot more information. But what I want to say about a PAD is this is a way that a person whose capacity fluctuates, like Dr. Avery's been talking about throughout the presentation, this is an opportunity for when a person has the capacity to express what they want in the event that they do lack capacity to give informed consent. This is a really effective way for the person to document their wishes and preferences and to incorporate it into their mental health treatment to the greatest extent possible. I think we're going to see these coming up in CARE Act proceedings as more people go through the proceedings and they have a PAD and they bring it to the court, and then the whole CARE Act team that's involved in supporting the person can become familiar with the PAD, whether through the behavioral health support team, volunteer support, or counsel. And so I am very interested to see how these are used during the CARE Act process to support the person's right to self-determination and to ensure in the event that they do lack capacity that there is documentation of their wishes and preferences. Okay, so let's go to the next slide. So Dr. Avery, Judge Cousins, I want to go back to Mary, and I want to ask you, now that we've talked about her situation and we've talked about her journey through the CARE Act process, how might you support Mary's decision-making in light of her need for treatment? So talking about the balance, right, between autonomy and self-determination, protection, stability, well-being. So I would invite both of your perspectives to this difficult question. Why don't we start with Dr. Avery and then go to Judge Cousins?
Yeah, that's great. Thanks, Daria. Yeah, I can jump in here. So I think one of the things that comes up with this vignette, Mary, is the idea of bridging the two concepts of incorporating Mary's values, health values and preferences, as well as incorporating the concept that Judge Cousins highlighted a few slides ago about voluntariness. Like, how can we enlist Mary in making a voluntary decision? So one concept, so how do we get to those values and preferences in the first place if Mary perhaps at present time doesn't appear to have capacity or the ability to express those? Well, one of them is, as Daria just mentioned, was the idea of if there's advanced directives in place, you can refer to those. But the other thing, as highlighted here on the slide, is other individuals in Mary's life may know what her preferences and values are or would have been. And so pulling in family members, other elements of her natural support system, maybe even just pulling in other care providers, a trusted therapist or a care manager or whatnot. Why do I highlight this? And how do we bridge that to the voluntariness? It's because it's not unusual for, in any one individual's situation, for there to be roughly equivalent treatment options out there. For instance, one antipsychotic versus another antipsychotic, the choice may be roughly equivalent, but Mary might have a preference or might have stated a preference, perhaps in advanced directives, but also perhaps to other family members. Getting to that, knowing what that preference might have been. So at some point when Mary is interested in taking that medication, that the medication that would have been her selection is there waiting for her as opposed to something else. So that's the way that I see that you can bridge that voluntariness while also bringing in the values and preferences that Mary may have. Judge Cousins, any other thoughts? Yeah.
Yeah, I absolutely support that, Dr. Avery. And I want to emphasize uh, again, the ability of the court to broker people and broker resources, and pick and choose, and draw people in that can make a contribution. You touched on that. I wanted to touch on it again to make sure that is a core part of Mary's process here. And then I think the other thing I'd like to emphasize is there is often very little to gain to force an action through the courts, particularly an action involving behavioral health issues, unless there's a particular crisis. Generally speaking, taking a breath, taking a continuance, a timely one where some additional things can happen out of the courtroom with the individual, can buy a little bit of time, not force the person into thinking a decision has to be made on the spot. There are timelines that the legislature has prescribed for the care process, but timelines are waivable. And with a showing of good cause made by the parties to take a breath, take a time out, work with Mary, for example, making sure she understands what her options are, time to bring in additional people can pay off in huge dividends without formalizing everything. Because as we all know, there's a huge difference between a voluntary participation in the care process and the court mandated care plan. It's a huge difference in the number of hearings you have to have, the review hearings and so forth. So it's a much simpler process. And so we can do ourselves all a favor, including Mary, by taking the time necessary to process the case in an efficient way, but a sensitive way.
Thank you, Dari, Mark, and Judge Cousins for that discussion and application of how the assessment of capacity and informed consent can apply to Mary and her journey through the care process. Again, the goal is that by the end of this training, participants will have an increased ability to, one, describe the concepts of capacity and informed consent in the context of the CARE Act, then define the factors that ensure informed consent that Dr. Avery went over, and then list some strategies to support the respondent to give informed consent that both Judge Cousins and Dari mentioned in that last section. So we appreciate you three joining us for that conversation and helping us better understand those ideas. I want to highlight a few next steps for you. We post all of our trainings, the recordings and the materials, so the slides with the talking points, on the CARE Act Resource Center. There are other opportunities to get engaged, and you can submit questions and TA requests on our website. A couple other related trainings that could be beneficial to view in conjunction with this training are our trainings on supported decision makings. We both have a version for volunteer supporters, and then also for implementation teams to better understand supported decision making. And like Dari mentioned, we also have a training on psychiatric advance directives and the reference to PATS in care. So there is no wrong door. So if you have a question or a comment, or you want technical assistance related to the CARE Act, please view our website, or just send an email to info@careact.org, and we can route you to the right resource. Thank you, and we look forward to hearing from you.